Welcome to Politics Nation. I'm Al Sharpton. News in the Trayvon Martin case. Newly released documents revealed the key parts of the prosecution case against George Zimmerman. We got copies of these documents today, just after Mr. Zimmerman appeared in court for the first time. Zimmerman went before a judge to face charges of his fateful 911 call. We heard him speak.
You're appearing here for your first appearance at this time for charge of murder in the second degree, and you are represented by Mr. O'Mara. Is that true?
Yes, sir.
The judge has ruled there is probable cause in this case, so it will move forward. Zimmerman will be formally arraigned on May 29th. The release of the probable cause documents are a big deal, shedding new light on how this case will be prosecuted. Prosecutor Angela Corey writes, quote, Trayvon Martin was on his way back to the townhouse where he was living when he was profiled by George Zimmerman. Martin was unarmed and was not committing a crime. Zimmerman observed Martin and assumed Martin was a criminal. Zimmerman felt Martin did not belong in the gated community and called the police. He goes on to say that Zimmerman perceived Martin to be acting suspiciously. The affidavit said that Zimmerman did not use a racial slur. It reveals that investigators have talked to Martin's girlfriend and that Zimmerman started the conflict. It says, quote, Martin attempted to run home, but was followed by Zimmerman, who didn't want the person he falsely assumed was going to commit a crime to get away before the police arrived. Zimmerman got out of his vehicle and followed Martin. Zimmerman disregarded the police dispatcher and continued to follow Martin, who was returning home. Zimmerman confronted Martin, and a struggle ensued. To help us break down this case, I'm joined by Ken Padowitz, a former homicide prosecutor, and John Burris, an experienced criminal defense attorney. Thanks to both of you for joining me tonight. Ken, let me start with you. Is this the roadmap the prosecution will use against Zimmerman?
Absolutely. It's kind of like the skeleton to the case that the prosecution is going to lay out before the jury. It definitely goes into the type of evidence that they have, how they're going to prove the elements to the charge of second-degree murder, and how they're going to prove their case beyond and to the exclusion of every reasonable doubt before a jury. Now,
John, the prosecution must prove for conviction. A, the victim is dead. 2, the death was caused by a criminal act by the defendant. And 3, the victim unlawfully killed by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. That's what they have to prove in second-degree murder in Florida. And if convicted, Zimmerman will face 25 years to life in prison. In your opinion, and you've been a defense attorney, do you think that they would have moved for murder to as opposed to manslaughter unless they felt they had evidence to back this up?
Well, you would think they would have, but I don't necessarily think that they really believe totally that they can get a second-degree murder conviction. I think the case was clearly on its face as a manslaughter. And the reason why I say that is this. There's going to be this whole question of the initial stand your ground. That's going to go out. They're not going to be able to win that at all. I mean, the defense isn't. But when you get down to a fight, regardless of who is the aggressor, there's a fight going.
You mean Zimmerman will not be able to prove stand your ground?
No, he is not going to be able to prove that because he is the aggressor and he pursued him. But when you get into the middle of a fight, a struggle, no matter who started it, if Zimmerman basically believes in good faith that his life is in danger, even though it's unreasonable, and he shoots and kills Trayvon, that's still murder, and that's still that's a manslaughter case. And so now, on the other hand, if he's in a position to leave, he's on top, he leaves, and he could have left, and he didn't leave, and he shoots him and kills him when his life is not in danger, that is deprived state of mind, and you can get a second-degree murder based upon that.
So a lot of it will depend on what we we don't know the evidence that they have, because, Ken, there is a lot of evidence clearly that we don't have. And we don't have the video of Zimmerman's police interview. We don't have the full police report. We don't have the autopsy results. We don't have Zimmerman's gun ballistics. We don't have Zimmerman's clothing to see whether there's blood splatter. I mean, there's a lot of things that we don't have, and there was an agreement to not release certain things at this point.
There was, but this was a brilliant legal move by the prosecution team. And what they did is they had to have sufficient evidence that they believed in good faith that they can come back to a jury and get a conviction for second-degree murder. But it was a brilliant legal strategy if they have that evidence, and I believe that they wouldn't have gone forward as they have if they had not, in fact, concluded they do have that evidence. It's kind of like an upside-down pyramid. The higher the charge, the higher up on that pyramid, the more evidence that is required in order to prove the elements of the charge. For second-degree murder, you went through the 3 elements that have to be proven by the state of Florida, and the state obviously feels that by going before a jury with a second-degree murder charge, they're giving the jury an option. They're giving them the option to come back with guilty as charged of second-degree murder, or to compromise their verdict and come back with a manslaughter conviction, which I'm assuming that the prosecution would look at as a win as well, because a conviction for manslaughter or second-degree murder would be a conviction.
So they can, by going for the higher charge, they probably feel they have the evidence, but they also feel in a compromised verdict they could get at least manslaughter, and a jury can do that.
Absolutely. I think the jury has the right to do that.
Right. Now, John, let me ask you this. The affidavit released today uses some strong language. It says, this is the prosecutor, not the protesters, not the activists, not any of us. It says that Martin was profiled. He was profiled by George Zimmerman, assumed Martin was a criminal. Zimmerman assumed Martin was a criminal, and that Zimmerman felt Martin did not belong in the gated community. However, the affidavit makes sure to note that Zimmerman did not use a racial epithet. Later, while talking about Martin, Zimmerman stated the a-holes, they always get away, and he also said these punks. Now, but that is not the racial term that some thought that they heard, but it doesn't help him with a state case because it sounds a little aggressive to me. It doesn't sound like a guy talking about somebody he doesn't know that he had to defend himself against. So it may help him with the feds, but it may hurt him with the state. Don't you think, John?
Absolutely. I don't think that. I think that the racial component goes out from the federal civil rights. But from a state point of view, you have a mind of a person who, in fact, was profiling this person and who was making decisions about him based upon a stereotypic notion about an African-American male, whether you call it race or not. He was basically saying he didn't belong here. He didn't like the way he was dressing. He was up to no good. That all goes to his state of mind that's consistent with him being the aggressor. And I think this is what the part that knocks out the stand-alone, stand-your-ground defense. So these background and these statements, I think, are pretty strong evidence that this is not going to, the prosecution is basically saying this is not a stand-your-ground defense here, given all the things that he was saying and doing at the time that clearly suggested he was the one that was trying to find out about this particular kid, and the kid wasn't trying to do anything to him.
Ken, this strikes me as a very strong statement, because here you're dealing now with a hard-nosed prosecutor who, by all accounts, is very much hard on criminals, very pro-police, a Republican, and she used the term in the affidavit profile. That's a real strong term in Florida, wouldn't you think?
Absolutely. It's a strong term because that's exactly what the evidence shows. We've all heard the 911 tape. We have an amazing piece of evidence it's a window into the mind of Mr. Zimmerman when he uses the term they. They always get away with this. Well, he's obviously, by saying that, he's profiling this individual. We don't know if the profile is young people, if it's people that wear hoodies, or if it's the fact that he's black. But he's obviously profiling this person, and now he's actually stalking him and going after him. He's the aggressor. And Florida statute is very clear that you can't even claim in front of a jury self-defense when you assert that. You can't claim that when you are, in fact, the aggressor. And the evidence seems to indicate very clearly that Mr. Zimmerman is the aggressor in this situation.
So profile could be racial, it could be his dress, it could be any number of things, but the fact that his profiling does take away from a self-defense or stand-your-ground defense is your point, Gim.
I think that's true. I mean, because he has a state. I'm sorry, I thought you said, but it goes to state of mind.
John.
It goes to his state of mind. When he uses the term "they," they always get away with it. That means he has in his own mind a stereotypic notion about a class of people, regardless of whether it was young African Americans, etc. He's already made a determination that, quote, they are people who do bad things, and he is going to put a stop to them. He's going to be the aggressor here. He's going to be the law enforcement officer. So I think that you have all this activity here that certainly suggests that this is a guy that the prosecution can clearly say he was the one that was the aggressor, and there's a lot of evidence to support that, and that tape, as short as it may be.
Now, when you combine that as well with the fact that he was the aggressor in terms of making these kind of strong statements, with the fact that the dispatcher, according to the affidavit and according to what we've heard in the 911 tape, told him to don't follow him, and he did anyway, it begins to line up as to why we can see the prosecutor feels they have a strong case, and we're only dealing with what we know. We don't know the evidence that has not been released yet.
Well, I think that's true.
Remember the third element to second-degree murder is act imminently dangerous to another, evincing a depraved mind. Clearly, the mind of Mr. Zimmerman is showing that he has ill will, spite, evil intent. He's showing a depraved mind. And that is one of the elements, the third element to the three elements of second-degree murder.
All right, Ken and John, stay with us for, I want to talk to you in a minute or more about the controversial stand your ground law. But coming up, the case against George Zimmerman rests in the hands of Special Prosecutor Angela Corey. By now, we all know her, but what's her record? Plus, George Zimmerman walked into courtroom today, but the controversial stand your ground defense could set him free. We'll look at that controversial law. And remembering the victim, why we can all relate to Trayvon and why the country can never forget.